All right, let's get right into it. We're talking about bail, one of the most critical parts of India's criminal justice system, and it's a hot topic right now because it's just gone through a massive overhaul. So in this explainer, we're going to break down exactly what bail is, how you get it, and what these new laws really mean. It's a nightmare scenario, right? To be accused of a crime. And it brings up this terrifying, immediate question. Do you have to sit in jail while your case crawls through the courts? We're talking months, maybe even years. Well, the answer to that question, thankfully, lies in the principle of bail. This one sentence from the Supreme Court. This is everything. It's the bedrock, the entire philosophy behind bail in India. It sets up this incredibly powerful idea that your liberty is the #1 priority. You are presumed innocent until proven guilty. And that means locking someone up before they're convicted should always be the absolute last resort, not the first move. So here's our game plan for today. We'll start with the why, the core idea behind bail. Then we'll walk through the 4 main ways you can get it. After that, we'll get practical and talk about building a strong bail application, look at the big changes in India's new laws, and finally cover what life is like when you're out on bail. Okay, first things first, let's really get to the heart of this, the guiding principle. Why does our legal system work so hard to protect the freedom of someone who's just been accused of a crime? So, in the simplest terms, bail is your ticket to temporary freedom. It's a legal safety valve that lets an accused person get out of custody so they don't end up serving a sentence before they've even had a trial. And this all comes back to that golden rule of justice. You are innocent until proven guilty. And make no mistake, this isn't just some minor procedural thing. It's a fundamental right. It's written right into Article 21 of our Constitution, the part that guarantees every single citizen the right to life and personal liberty. Bail is the tool that makes sure that right isn't just tossed aside because of an accusation.
So, how does this big principle actually work in the real world? Well, if you're trying to get out of custody, there are basically 4 different legal doors you can try to open. Let's break down each one. First up is regular bail. This is the one you hear about most often. It's what you apply for after an arrest has already happened. So whether you're in a police lockup or in judicial custody, this is your standard application to get released while your trial is pending. And just a heads up, under the new laws, you'll find this covered in sections 480 and 483 of the BNSS. Next, we have anticipatory bail. Now, think of this one as a proactive shield. If you have a real, credible reason to believe you're about to be arrested for a serious offense, you can go to the court for protection before it even happens. It's an absolutely vital tool to protect people from false cases or harassment. Third is interim bail. This is basically a short-term emergency release. It's granted for a brief, specific period while your main bail application is still waiting to be heard by the court. You often see this used in really urgent situations, like a family medical crisis, where someone needs to get out right away. And finally, there's default bail. This one is a huge deal because it's an automatic right. It's not something a judge grants out of kindness. The law says if the police don't finish their investigation and file a charge sheet within a set time, usually 60 or 90 days, the accused person is entitled to be released. It's a powerful check on the system to prevent people from languishing in jail indefinitely. Okay, so we've got the 4 different types down. But how do you actually convince a judge to grant one? Let's get into the nitty-gritty of what makes a bail application strong. The whole process really boils down to 4 key steps. First, you have to pick the right playground. The court's level depends on how serious the alleged crime is. Next, you draft the actual application, laying out all the details and your arguments for why you should get bail. Then you file it. And finally, and this is crucial, you have to give a copy to the public prosecutor, so the other side knows you're asking for a hearing. Now, when you file, you need to bring the right tools. Think of it as your bail application toolkit. A copy of the police report, the FIR, and an ID proof for the accused. Those are your must-haves. But to really build a strong case, you want to add things that show the person has roots in the community and isn't a flight risk. Things like medical records, a job certificate, property documents, and even character references. So what's going through the judge's mind when they're looking at all this? Well, they often use something called the triple test. They're basically asking themselves 3 simple questions. 1, is this person going to run away? 2, are they going to mess with the evidence? And 3, are they going to try and threaten or influence witnesses? Your entire application is about convincing the judge that the answer to all 3 of those questions is a firm no. All right, now for the part that's shaking everything up. The old rule book, the Code of Criminal Procedure from way back in 1973, is out.
There's a new law in town, the Bharatiya Nagarik Suraksha Sanhita, or BNSS for short. Let's look at what's changed. And here it is, the cover of the handbook for the new law. This signals a massive shift in India's criminal procedure. Now, the core ideas of bail are still there, but the BNSS brings in some really important updates that are designed to modernize the whole system. Okay, check this out. This is one of the biggest changes, and it deals with how long people can be held in jail before their trial even ends. The old rule about getting released after serving half the maximum sentence is mostly still there, but the BNSS adds something completely new and pretty revolutionary for first-time offenders. Now, they can be considered for release after serving just 1/3 of the maximum sentence. This is a potential game changer for reducing the insane overcrowding in our jails and easing the burden on families.
So you've gotten bail. Great. But hold on, it's not a free pass to do whatever you want. Getting bail means you've been released on certain conditions. You have to play by a very strict set of rules to stay free until your trial is over.
And these conditions are all tied back to that triple test we talked about. They'll probably make you surrender your passport. That's to make sure you don't flee. They'll tell you not to contact any witnesses. And you'll have to provide a bail bond, which is basically a financial guarantee that you'll show up to court, often backed by a surety, someone who co-signs that promise. The choice here is pretty black and white. You follow the rules, you stay free. You can even go back to the court and ask them to ease up on a condition if it's too harsh. But if you break the rules, the consequences are swift and severe. Your bail gets canceled, a warrant goes out for your immediate rearrest, and you lose all that money from the bail bond. So, when you boil it all down, bail is this incredibly delicate balancing act. On one side, you have a person's fundamental right to freedom. On the other, you have the need to keep society safe and ensure a fair trial. The new BNSS laws are our country's latest attempts to get that balance just right. And that really leaves us with the big question to think about. As these new laws actually start being used in our courtrooms day in and day out, are we getting any closer to perfecting that incredibly tricky balance between individual freedom and public safety? I guess only time will tell.